The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hello, everybody. Welcome to the Law of Self-Defense News and Q&A show it's for yesterday, November 19th, 2020. Today, of course, is November 20th. Sorry about that. We missed the show yesterday. Had to push it back 24 hours. I appreciate all your patience. For those who don't know, I am attorney Andrew Branca for Law of Self-Defense. Thank you very much. That is always greatly appreciated. So come on in, folks. Get settled. This is our weekly news and Q&A show. We generally do it every Thursday, 4 p.m. Eastern Time. This week, of course, we're doing it on Friday because of a slight emergency on our end just today, which got taken care of. No worries. Happy to only have to push it back a day. This is the only content we produce on a weekly basis that is open access, meaning you don't need to be a Law of Self-Defense member to enjoy this content. It's free to everybody. And we do this, of course, every week as an opportunity to expose the broader public to what we do at Law of Self-Defense, which is a law practice that focuses exclusively on use of force law, meaning defense of yourself, defense of others, defense of property. It's all we do. To my knowledge, we're the only law practice in the U.S. that has that particular focus, and to provide a lot of educational, informative information on the law of self-defense to all of you to help you be more actionable and decisive in defending yourself and your families from criminal predation. So in our news and Q&A show, of course, we'll share some any interesting use of force events that have been in the news. Frankly, the news is still completely occupied with political stuff from the election, which seems to have swamped everything else. But we do have a couple small stories to share with you. Then we will answer your questions. Now, a bunch of questions have been sent in ahead of time. Those of you who are Law of Self-Defense Platinum level members have your own Platinum level form for submitting questions. Those get answered directly by me, either privately, if you prefer, or on the show, prioritized above all other questions. Everybody else can send in questions to us by email at show@lawofselfdefense, and we'll consider them for inclusion in the show as time permits. Those of you who are Law of Self-Defense members at any level, I encourage you to participate in the show using the stream on your member dashboard. There's commenting capability there. And again, member questions get prioritized above all others. If you're joining us on Facebook, welcome. Please hit that share arrow at the top of the comment screen, that like, thumbs up. Let a friend or two know that you're enjoying the show so they can join us as well. And if they can't make the live show at 4 p.m. Eastern Time, or if you ever can't make the live show, you can also still catch the playback recording of the show either on Facebook or on the lawofselfdefense.com blog, where it will remain open access for some time anyway. So let your friends know they can catch either the live show 4 p.m. Eastern Time on Thursdays, or they can catch the playback recording at the lawofselfdefense.com/blog or on our Facebook page at facebook.com/law of self-defense. Also our YouTube channel, and sometimes other places as well. But our webpage, lawofselfdefense.com, Facebook and YouTube should certainly have the recorded playback of this particular weekly news and Q&A show. Before we dive into things, a quick mention from our usual sponsor, which is CCW Safe. CCW Safe, of course, is a provider of legal service memberships. What many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if their member is involved in a use of force event. And those expenses get big fast, folks. Imagine a situation where you're threatened in some manner. You present your gun to change that attacker's behavior. It works. He runs away. You didn't have to shoot anybody. You didn't have to hurt anybody. Not a shot was fired. Then you find yourself charged with aggravated assault with a firearm. And now you have to raise the legal defense of self-defense. You'll be retaining an attorney with a initial retainer of somewhere in the range of $30,000 to $50,000 for pre-trial work, folks, not for going to trial. Trial is going to cost above and beyond that. If you've had to shoot someone in self-defense and you've killed them and you find yourself charged with murder or manslaughter, you could easily be looking at $100,000 or $200,000 pre-trial expense. Just multiply that for the trial. So it can be helpful if you don't have that kind of money stuffed in a mattress in case you ever have to defend yourself or your family, to have a financial partner to provide the monetary resources you need to fight that legal battle the way you'd like it fought, which is as if your life depended on it, because it really does. And that's what CCW Safe offers to do. Now, I've looked at all these various programs out there. CCW Safe has competitors, of course, and I found that CCW Safe is the best fit for me. I'm a member of CCW Safe. My wife, Emily, is a member. And I should mention one of the reasons I picked them was because many of their competitors have a cap, a limit on the amount of monetary resources they'll provide for your criminal defense. And those caps are invariably way too low, folks. At least one major competitor, CCW Safe, caps their coverage at $150,000 or $250,000 for criminal defense. As I said, if you've shot and killed someone in self-defense and are being charged, you'll go through $200 pre-trial without much trouble. So $250 is not enough. And what if you lose a trial and you have to appeal? CCW Safe covers you on appeals, again, with no cap. These other companies often say, well, we'll cover you up to the limit of the cap on an appeal. But of course, you'll have spent all that money at the trial itself. So effectively, there is no coverage for an appeal. So be aware, if your plan that you're looking at or already have has that kind of cap. I know $250,000 sounds like a lot of money, folks, and it is a lot of money, but not in the context of a criminal defense in a murder or manslaughter case. Now, I've said that CCW Safe is the best fit for me. I'm a member. Whether they're the best fit for you is something only you can decide. But I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off your membership with them at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense, and the number 10. Okay, back to our news and Q&A show. Now, of course, we have our own membership, as I mentioned here at Law of Self-Defense, either standard membership or platinum level membership. Standard membership gets you access to all the member content that we produce through the course of the week, the month, the year, which is a ton of content. To give you an example of the kind of content we've delivered to our members just this week, earlier this week, we did and all this content is delivered as a written blog post, as video, much like you're watching now, and also as audio on our Law of Self-Defense members only podcast, if you like podcasting. But earlier this week, we did a blog post on a self-defense event, a court decision involving the legal doctrine of imperfect self-defense. So perfect self-defense is a normal self-defense. The legal defense is self-defense. If successful, it acquits you. It relieves you of all criminal liability. Your use of force was simply not a crime, so there's no criminal liability. Imperfect self-defense is a variant. It's not really a legal defense in the sense that it can't lead to an acquittal, but basically it says, if you had a genuine good faith belief that you were acting in lawful self-defense, but a jury determines that belief was genuine, but objectively unreasonable, you can't get acquitted. You don't qualify for perfect self-defense. But you may qualify for imperfect self-defense and be able to mitigate what would have been a murder conviction, life in prison without possibility of early release, to a manslaughter conviction, perhaps 10 or 20 years, maybe early release after a third of that time for good behavior, still have a life again. So manslaughter conviction sucks unless the alternative was a murder conviction. So that's how imperfect self-defense works. This happened to be a case of a woman who stabbed I guess I'll call him a boyfriend, under circumstances where it appeared to her that she had a genuine good faith belief in the need she was facing a deadly force threat. He was unarmed. She stabbed him once with a knife. Not very, well, you wouldn't think very deep, a couple of inches, was enough to clip his aorta, and that was the end of that. So that appellate court decision, talks all about the legal doctrine of imperfect self in that context. Then we had, surprisingly, really, another case in our next blog post also covering imperfect self-defense. This case was interesting because here the defendant was arguing imperfect self-defense as if it allowed him to create his own elements of self-defense, his own version of self-defense. That's not what imperfect self-defense does. Imperfect self-defense says, hey, these are the elements of self-defense. You have to genuinely, in good faith, believe those elements exist, the actual elements, not some fantasy elements you may have in your head. Those actual elements, you must have a subjective belief they exist. If that subjective belief is unreasonable, but you did believe in the actual elements, well, then you may qualify for imperfect self-defense. If you had a vision of self-defense in your head that's completely independent of what the law allows for, well, sorry, that's just not a legal defense at all. So we covered that blog post as well. And then a blog post that just went up a few minutes ago is on a very interesting court decision that came out of the Georgia Supreme Court just in the last couple of weeks, November 2nd, 2020. It involved the arrest by 3 officers, of course, as seems common in these cases, 3 white officers arresting an unarmed but non-compliant black male suspect under circumstances in which I think, to their surprise, as much as anybody else's, he died. They did use a taser to attempt to force compliance, and he died. They were all charged with felony murder predicated on aggravated assault, predicated on unlawful imprisonment, as well as involuntary manslaughter, predicated on reckless conduct, predicated on simple assault. So they're basically, each of those 3 deputies is facing charges, 2 counts of felony murder, 2 counts of involuntary manslaughter. And they sought from the trial court before the trial, pre-trial, self-defense immunity, and were granted self-defense immunity, and the prosecution thought that was a bad decision, appealed it up to the Georgia Supreme Court, and the Georgia Supreme Court has vacated that self-defense immunity grant. So now those deputies have to go back to court, try for self-defense immunity again, or end up going to trial on those felony murder and involuntary manslaughter charges. And so in this post and video and podcast, we talk at length about self-defense immunity, how it works in general, how it works under Georgia law, and the specific factors in this case that led to the granting and then the removal of self-defense immunity and what's likely to happen. In fact, our analysis was so detailed, we actually had to break this one up into 2 parts because it's well over an hour worth of content. So we have part 1 went out today to our members. Part 2 will go out maybe tomorrow, maybe Monday, depends on how quickly we can get the post-production done before this evening. Now, that's all content that only our members get, folks, and we do that kind of thing every single week, every week of the year, every year of our lives. So we've been doing it a long time. We focused exclusively on self-defense law since about 1997, 1998. And we expect to continue doing it for a very long time. So if you'd like that kind of more detailed analysis beyond the news and Q&A show, I would encourage you to consider giving Law of Self-Defense membership a shot. It's very inexpensive to be a standard member. It's about 33 cents a day, less than $10 a month for hours and hours and hours every month of world-class self-defense law expertise, all translated into plain English. And even better, you can at least try it out for 2 weeks for just 99 cents. And if you, for any reason, decide you don't want to stay a member, that's fine. No questions asked. We'll give you 200% of your money back. And if you do decide to become a member, and virtually everyone decides to stay a member, it's still less than $10 a month, folks. So you can try out that trial membership for 2 weeks, 99 cents at lawofselfdefense.com/trial. All right. With all that house cleaning out of the way, so during today's show, I'll talk about a couple news items. Then I'll answer questions that were sent in ahead of time. Then I will address questions as they arise in the comments. So if you have questions and you're watching live, if you're watching the recording, folks, I'm not going to see your comments because I don't look at them retroactively. But if you're watching this live on either our member dashboard or the Law of Self-Defense Facebook page, and you have questions you'd like to answer, put them in the comments. If we have time before the end of the show, I'll do my best to answer those. First, a couple news items. There wasn't much really. A couple interesting things that came up was I saw a couple of cases in which people in Louisiana in particular were either being released from prison or were seeking new trials because of a change in criminal procedure. And for those who don't know, until recently, most of you are probably believe that if you're a criminal defendant in a trial, to be found guilty, the prosecution has to convince the jury that they've proven each and every element of the crime with which you've been charged beyond a reasonable doubt. And they have to convince the jury unanimously, meaning every single member of the jury. For felonies, typically 12 jurors. Some states allow 6 jurors for felonies. But they have to convince every juror that you're guilty beyond a reasonable doubt. And if there's even one juror that's not convinced beyond a reasonable doubt, you end up with a hung jury, with a mistrial. There's no verdict. Now, if that happens, the prosecutor's free to try you again, but at least you're not convicted yet. At least you're not going to prison yet. Although, of course, you may still be held in jail for the successive trial. That depends on the circumstances of the case, but at least you're still in the fight. There were two states traditionally that were an exception to that requirement of jury unanimity. And those were Oregon and Louisiana. And in those two states, you could be convicted by a supermajority of the jury. So 10 of 12 if it was a 10-person jury, 5 of 6 if it was a 6-person jury. So you didn't need a unanimous jury. And let me tell you, from the perspective of a criminal defense attorney, that sucks. One of the biggest things we have going for us in a criminal defense is the requirement that the prosecution has to convince everybody, every single person on that jury. That means if I can raise a reasonable doubt in even one juror's mind, we have a hung jury and we don't have a conviction. That's a win as far as I'm concerned. Not as big a win as an acquittal, granted, but it's a win compared to a conviction. We're in these states that allow for supermajorities where the prosecution only has to convince 10 of 12. Now I have to raise a reasonable doubt, not just in the mind of one juror, but in the mind of 3 jurors, which is, as you might imagine, potentially more difficult to do. So I've never been in favor of these split jury permissions. Now, that said, the Supreme Court has forever said that as far as they're concerned, split jury's fine. If a state wants to do that, that's up to the state. It's not a violation of the U.S. Constitution. And the U.S. Supreme Court had that position right up until this year. In April 2020, they handed down a decision, Ramos v. Louisiana, where a majority of the Supreme Court ruled that, nope, we've changed our minds. From now on, if you want to convict someone of a criminal offense, at least a serious misdemeanor or felony, it has to be a unanimous jury conviction. Well, obviously that changed the rules. In Louisiana, for example, people were being convicted 10-2 by juries, often for very serious crimes, life in prison. But now there's a new standard. If they were being tried today, it would have to be for 12 of 12 jurors, unanimous juror. So we're seeing some people get released from prison, presumably, purportedly on this basis. Hey, they were convicted 10-12, sentenced to life in 10-2, sentenced to life in prison. If they had to do it today, it would have had to been 12 of 12. They served 30 years in one case. Let's let them out. Now, the cases we're seeing getting released right now are kind of sympathetic cases. So one of them was a woman, Edna Gibson. In 1986, she stabbed her husband. She had claims of domestic abuse. But a lot of these cases, spousal abuse cases, are cases in which the spousal abuse may be genuine and may have driven the killing of the spouse. Typically, it's the woman killing the husband, but under circumstances that don't fit the traditional framework for self-defense. So the husband was passed out or asleep, and the abused wife stabs him or shoots him or pours gasoline on him and sets him on fire. All kinds of interesting ways to kill your spouse, I guess, if you're sufficiently motivated. But in those instances, the woman who killed was not facing an imminent threat of harm. Maybe a future threat, certainly a past threat, but not the imminent threat that traditional self-defense requires. So they couldn't get acquitted on the basis of self-defense. They'd get convicted. But as you might imagine, there are arguably more sympathetic cases than other killings that were unlawful may seem to be. So one of these cases recently, Edna Gibson, she was killed her husband, stabbed them, was convicted, sentenced to, I actually don't know how long her sentence was, but she'd already served 30 years when the state of Louisiana decided to release her because she had been convicted on a 10-2 basis. A more recent case involved the football player Will Smith. Those of you who are football fans may know he played for the Louisiana, I guess the Saints, right? And he was killed in a road rage traffic confrontation. Cardell Hayes shot him and killed him. Cardell Hayes was convicted on a 10-2 vote by the jury. He's now seeking a new trial because of the rule change. And if you don't know the history of this, and I can't say I know the history, this is just what I've heard. I haven't looked into it personally, and sometimes obviously what you're told about history is incorrect. But the argument has been that these split jury provisions were based, out of racism by Confederate states that were arguably suddenly discovered they were having to allow black people on juries, and they didn't want a black suspect to be not convicted because there was one, for example, black juror on a jury, I should say. And so they allowed for supermajority as opposed to unanimous. jury convictions. Anyway, that's not allowed moving forward. And I think we'll see more cases where people are getting new trials or are being released prior to, especially life sentences, that were convicted on a 10-2 basis. We had another interesting case, no, not very interesting, but it's just another reminder that if you read stories about use of force law in the media, they're almost always wrong. This was a case in which a politician in Florida, happens to be a Democrat, had sent online threats to several prominent Republican politicians, including the governor, DeSantis, the Senator Rubio, Scott, I guess, is the other senator in Florida. Anyway, she sent them all online threats, and they reported it, and she's been charged with sending online threats. And that part's not that interesting. There's crazy people everywhere. What's interesting is the news story that wrote about this. Of course, they had to bring up stand your ground, which, of course, is completely irrelevant to anything to do with this story. But if you mention Florida and use of force law, the media feels compelled to bring up stand your ground, which they describe in the following way. Quote, unique to self-defense laws in other states, the Florida Stand Your Ground statute does not require a person to retreat before using deadly force to prevent bodily harm to themselves or others or to prevent a felony. Close quote. While it's not unique to Florida, folks, it's the majority position in America. The large majority of states, about 75% of states, are stand your ground states. They do not impose a legal duty to retreat before you can use force in otherwise lawful self-defense. There's only about 14 states that impose that legal duty to retreat. If you'd like to see what they are, you can point your browser to lawofselfdefense.com/retreat, and it has a list there. But imposing a duty to retreat is not the position of 49 states, as this quote-unquote journalist would suggest. It's the position of a mere 14 states. That's it, folks. Okay, let's get to the questions here. Now, we had a couple come in from one of our Platinum members, Lorraine, and very interesting questions, so very happy to answer those. One of our questions is, if I disarm an attacker and then use that weapon that I took off the attacker, whether it's a gun, knife, bat, whatever, against him or her, would that flip the situation, making me the attacker? Great question. So the answer is, of course, I'm going to say it depends. But the analysis is exactly the same as it is for any other use of force event. So when you're being attacked by that person, the question is, before you can use force in self-defense, are you facing an imminent, unlawful threat of force? And if we want it to be deadly force, then imminent, unlawful threat of deadly force. If you are, you're privileged to use deadly force in self-defense, assuming, of course, that all the conditions of self-defense are met, like if you have a condition to retreat and so forth. Well, that same analysis applies if the conditions flip. So someone's coming at you with a raised bat, they're screaming they're going to kill you, you have no real ready means to retreat, say. They're within a few feet, and somehow, I don't know, they trip over their own shoelace, they drop their bat, and now you have the bat. If you use the bat to attack them, are you now the aggressor in a second fight? Well, the analysis is the same. Before you can use force against them, do they, in that moment, represent an imminent threat of deadly force harm? Or have they lost that ability because you've taken away their bat or acquired possession of their bat? Sometimes when they lose the bat and you pick it up, circumstances have changed enough that they're not any longer a credible or reasonably perceived imminent threat of deadly force harm. Sometimes they are still. You could imagine a large man with a bat attacking a woman. He trips over a shoelace, drops the bat, she picks it up. Maybe she's a very small woman, 100 pounds. He's 280-pound guy. Is he still a deadly force threat if he continues to attack her with that size disparity, despite the fact that he's unarmed and she's got a bat? I'd argue, yeah. Not that hard for him to take the bat away from her again. So he could potentially still be a deadly force threat. Her use of the bat would still be self-defense because it would meet those conditions. She's still facing an imminent threat of deadly force harm from him. But what if the conditions were reversed? What if it was a 100-pound woman attacking a 280-pound man? She's got a bat. She trips over her heels, let's say, to be sufficiently sexist, I guess. And she drops the bat. He picks it up. Now this 280-pound guy has the bat. Can he use the bat against her and have that be lawful self-defense? In other words, is she still, having lost to him possession of the bat, is she still an imminent deadly force threat to him? Probably not. Probably he does not need to use deadly force against her to defend himself because she's no longer, absent the bat and given the size disparity in his favor, an imminent deadly force threat to him. So the analysis is always the same. Before you can use force against another person, in that moment, do they still represent an imminent threat of unlawful harm? And then, of course, the element of proportionality requires us to assess the harm, what the degree of harm, whether it's merely non-deadly force harm, in which case we can only use non-deadly force in self-defense, or whether it's deadly force harm, in which case we can use deadly force in self-defense, the other conditions, self-defense presumably having been met. It's always the same analysis. What's complicated is not the self-defense analysis per se, folks. There's only 5 elements to a claim of self-defense. And by the way, if you don't know what those are, if you're new here because you're watching it as free content, we have a handy-dandy infographic you can get. Doesn't cost a penny. 5 elements of self-defense law infographic. It's just a PDF download, folks. You can get that at lawselfdefense.com/elements. It lists the 5 elements, provides a brief description, because if you don't know that, you can't understand anything else about self-defense. So when I talk about these 5 elements, if you have no idea what I'm talking about, you've never been exposed to them, these are the 5 elements of self-defense in all 50 states, folks, at least only up to these 5. So the good news is there's not 500, there's not 50, there's only 5. It's not that complicated a legal framework. What's complicated is the real world. The real world is messy. Facts are messy. Fights are dynamic, circumstances change. So it can get complicated to try to apply those 5 elements to that messy, complicated, dynamic world, which is what we try to help do with all of you in all the content we prepare at lawselfdefense.com. Lorraine asks another excellent question. She goes she says, in a previous show, you mentioned the potential legal jeopardy created when brandishing, quote unquote, a weapon to change the behavior of a potential attacker. Would simply telling the attacker that I'm armed, concealed carrying, or with a knife also put me in jeopardy? I presume she means legal jeopardy. Please include scenarios where I'm actually carrying and not actually carrying, but lying about carrying. So what Lorraine's referring there to is I've mentioned frequently in the past that the moment you put someone in imminent fear of physical harm for the purpose of changing their behavior, which is what you're doing when you're threatening to use a weapon in self-defense, right? You're saying, stay back, I have a gun, I'll defend myself. Or you're displaying your gun, or you're pulling your jacket back so they can see your gun. All of that is threatening someone with harm for the purpose of changing their behavior. Now, you can justify that as lawful self-defense and therefore not criminal conduct if you meet the conditions for self-defense. But the point is, the moment you've engaged in that behavior, you've put someone in fear for the purpose of changing their behavior. Once you've done that, now you're in a position where you may well have to raise that legal defense of self-defense to justify that conduct. Before you do that, you haven't even arguably committed a crime. Once you've done that, you've checked all the boxes for aggravated assault. The felony crime of aggravated assault, and if you did it with a weapon, aggravated assault with a weapon, which is certainly a felony everywhere. If it was a gun, there might be a gun sentencing enhancement, so you could be looking at up to 20 years in prison in many states. Because the crime of assault is simply the putting of another person in imminent fear of harm. Aggravated assault, putting that other person in imminent fear of death or serious bodily injury. Well, when you threaten someone with a gun, you're doing that. Now, if you're threatening someone with a gun because the conditions for lawful self-defense have been met, well, then you could be justified in having done what would otherwise be unlawful conduct. If you do that and your conduct doesn't meet the conditions of self-defense, well, then it's just normal aggravated assault with a firearm, and you're looking at a very serious criminal charge. Most of the cases I personally work on are aggravated assault with firearms cases because they're normally law-abiding people who've never been in trouble with the law a day before in their lives, but they have a concealed carry permit. They have their gun on their person. They get frightened. They go to the gun, and it's ambiguous to the prosecutor whether or not the conditions for self-defense have been met. So they get charged. You want to prove it? You want to prove self-defense? Do it at trial, which, of course, is enormously destructive and costly, sometimes financially ruinous for this poor defendant. But That's what can happen. That's within the prosecutor's discretion. So the moment you make someone else aware you have that weapon for the purpose of changing their behavior, you've opened the door for a prosecutor bringing a charge like that, aggravated assault with a weapon that you now have to justify at great cost and risk as conduct justified as lawful self-defense. Now, what if you actually do you even need to show the person the gun? What if you're carrying concealed, but you never display the gun? You never show it to them. You just say, hey, I have a gun. I'm prepared to use it. Well, have you created in that other person's mind a reasonable fear of imminent death or serious bodily injury? Yes, you have, assuming they believe you, right? I mean, if they don't believe you, it doesn't matter. But what counts in terms of the crime of aggravated assault is that your conduct creates a reasonable apprehension in the other person's mind. It doesn't matter whether or not they see the gun. What matters is whether or not they reasonably have that apprehension of imminent death or serious bodily injury at your hand. In fact, because all that matters is the reasonable apprehension, you don't actually need to be able to carry out the threat. Say you have a gun on your person, but it's a toy gun. It's a plastic gun. Can't possibly hurt anybody. And that's what you're displaying. And that puts that other person in reasonable apprehension of immediate death or serious bodily injury. Have you committed aggravated assault? Sure you have. Because what matters is not what you're actually capable of doing, but what their reasonable apprehension is. If they perceive that toy gun as being real, well, then they're reasonably apprehending imminent death or serious bodily injury. And that's aggravated assault, putting someone in that fear. What if you don't even have a plastic gun? What if you have no weapon at all and you just lie about having a weapon? Well, if a reasonable person would believe your lie, then you've committed that aggravated assault, folks, because again, what matters is their reasonable apprehension, their reasonable perception of the threat. So yes, you can commit aggravated assault without having any weapon at all on your person. Now, prosecutors always have more cases to try than they could possibly take to trial. They're always prioritizing. There's always lots of plea bargaining going on, lots of charges dismissed going on. And they tend to prioritize the cases that are easier to win. It's easier to win an aggravated assault case in which there's a weapon in evidence. So if you don't have any weapon, it doesn't mean you can't be charged. It doesn't mean you don't have the legal risk, but it may be a reduced risk because there's no actual weapon in evidence, and it's just a less attractive case to a prosecutor. Of course, folks, I would suggest that there's almost never a reason to be totally disarmed, almost anywhere. So something to think about it. I'm not advising anyone to break the law. Most states have some kind of weapons law, and I would suggest you abide by those laws to avoid weapons law problems. But it's generally possible with forethought to be armed to at least some degree under almost every circumstance. All right, so hopefully that answered Lorraine's question. Excuse me. Okay, Alan. So actually we have two related questions here. One's from Alan, one's from Anonymous. They're basically asking the same thing. So Alan's asking, he says, I have a license to conceal in my state. What if a police officer demands to take control of my weapon? Are there circumstances in which I can refuse to be disarmed by that police officer? So that's Alan's question. Anonymous basically asks the same thing. So he lives in a state, well, I may as well say it's the state of Florida. That's the only state that has the act by this particular name, but they have an act called the Baker Act. Many states have a similar act. But the Baker Act is really if someone fears that you may be dangerous to yourself or others, they can call the police, and the police will come out and talk with you. And if they agree that you appear to be a danger to yourself or others, they can arrest you and lock you up for some certain period of time, during which, in theory, you'll be talked to by a psychologist or counselor or something to make a determination of whether you're actually dangerous to yourself or others. In a sense, it's not dissimilar from red flag laws, but I think in many important respects it is. I mean, the threshold for locking up a person and the due process rights that triggers are substantially greater when locking up a person than when simply seizing someone's guns, for example. And there are circumstances in which someone is genuinely a threat to themselves or others. Now, I think another way the Baker Act calls, and I'm speaking anecdotally here, not from as a source of authority by any means, but in my experience, I've been involved in Baker Act cases and red flag law cases. And in my experience, Baker Act cases are most frequently, those calls are being made usually by family members that are genuinely concerned. They have a parent, they have a child who they feel may be suicidal, for example. They don't know what to do. You have somewhat more control over a child, but not a parent. They don't want their parent to kill themselves. I think the parent's just temporarily in a bad way. If only they could secure their safety for 24 or 48 hours, maybe they could turn things around. They make that call. The sheriff comes out. Sheriff agrees the person appears to be under considerable emotional stress, may well be a danger to themselves. They get Baker Acted. They get locked up for a period of time. Now, obviously, when they lock you up, you can't bring your gun with you. So you'll be disarmed in the process if you are carrying a gun. Contrary to the Baker Act, I think a lot of red flag laws tend to be abuse calls. So someone's just mad at you, an ex-girlfriend, an ex-wife, and they just make a fictitious complaint that you've said something threatening, and the cops come and take all your guns away. So certainly I'm not a fan of red flag laws by any means, because I think they completely lack in due process. But I don't want to get off on that sidetrack. The other question is, if you have a license to carry and say you're stopped for a traffic stop or some other way approached by a police officer, maybe there's been a call of a crime committed by someone who matches your description, right? Your age, your hair, your clothing. Cop sees you, all right? You're someone who matches that description. I'm going to go talk to that guy. Makes a stop, has reasonable suspicion that you may be involved in the crime based on the description he received. So he can make a Terry stop. When he's making a Terry stop, he can disarm you for purposes of securing the safety of himself and others during that stop. Now, maybe he doesn't have reasonable suspicion, in which case a Terry stop would not be authorized. Maybe he just doesn't like the way you look. Who knows? But it's something less than reasonable suspicion that you may have been involved in a crime. Technically, under that circumstance, he can't disarm you. But what if he wants to anyway? Or what if you're part of a traffic stop and you tell the cop, hey, I've got my concealed carry permit, I'm carrying a concealed carry. And the cop says, well, I want your gun while we're going through this traffic stop. Let me ask you folks, does it really matter whether you have the right to not be disarmed in that circumstance from a practical perspective? Because there are factual circumstances in which you would have the right not to be disarmed. Are you going to have that argument on the side of the road with an armed police officer who, mistakenly or not, believes he has the legal authority to disarm you? I don't think that would be very prudent. I'm not planning to get into any gunfights with police officers on the side of the road just because they may be ignorant of where the boundaries of their legal authority is. If I have rights to assert in that circumstance, I'm going to do them after the fact. I'm certainly not also going to get into a gunfight with an officer who's doing a Baker Act call or, frankly, even a red flag call. Not in that moment. I'm going to assert my rights for sure. But I'm going to do it in a setting where it's not likely me or my wife or my kids behind me are going to be lit up because I got myself into a gunfight with a police officer who doesn't know where the legal limits are. So I would suggest that it's less important to worry about where the nuanced lines of the law are. Let your lawyer handle that after the fact than it is to, hopefully recognize the fact that you're not going to be willing to get into a gunfight on the side of the road or standing in your front door over what might very well be terrible decisions by that officer. Okay, Bob sent in a question about an old case, a few years old. It's been working its way through the system. So this was a case out of at Northern Arizona University involving a kid called Steve Jones, a kid, 18-year-old freshman, kid to me. And he and a friend or two were walking down the street. They got into a confrontation with some other college students, a different group, let's call them. Some kind of beating began to take place. I'm recalling the facts just from recollection, so I may not be completely clear in the details, but the facts aren't important for the key point I want to hit here. So there's a confrontation between these two groups of students. Stephen Jones, the defendant in this case, runs away, gets a gun, a handgun, comes back. I believe it was a Beretta. Comes back and starts firing shots, and he ends up killing one of the other group and severely injuring at least 3 others. In fact, one of them, I think, was very badly crippled, may have killed himself later, but very badly crippling 3 of the others. Gets arrested. Stephen Jones does after the fact. Gets charged with 1 count of first-degree murder, 3 counts of aggravated assault. And his argument is basically defense of others, defense of self. So when he ran away, his friend was stuck behind, still getting a beat down, disparity of numbers, likely to suffer serious bodily injury, deadly force attack. So he went and got his gun, came back to defend his friend. And of course, at that point, he's also defending himself, right? From a perspective, deadly force beating. So that was his argument, defense of self, defense of others. Of course, the thing that looks bad is you achieved a position of safety and then you armed yourself and you came back to the fight. So I'm sure that's what attracted the eye of the prosecutor. Also, of course, the damage that was inflicted. Now, I mean, we all know guns start getting fired, people get hurt pretty bad. They get killed, they get maimed. But in theory, I suspect, I should say, if he'd fired, shot once and the crowd had dispersed and it was a modest injury to somebody, or maybe no injury, maybe the shot missed completely, it would have been a less attractive case to a prosecutor. But when you have, the public in the community was pretty much screaming that, hey, this kid murdered someone and maimed 3 other young men with their whole lives ahead of them, it's a case with a lot of political energy that's attractive to a prosecutor. So anyway, they charge him with first-degree murder, 3 counts of aggravated assault for the 3 other kids he shot, and he argues self-defense, defense of others at trial, and he gets a hung jury. Now, if he'd gotten convicted, he would surely have been sentenced to life in prison without possibility of early release, but he gets a hung jury, so he's not convicted. So the prosecutor announces immediately, well, we're going to try him again, put him in front of another jury, and probably if he had a hung jury 10 times, the prosecutor would have retried him again. So it's going to be a never-ending process unless he can get an outright acquittal. And the question sent in from Bob was, hey, I was watching an old 2020 program, TV news program, about this case, and learned that this defendant, after he got his hung jury, they were going to prosecute him again, he took a plea deal. Why would he take a plea deal if he got a hung jury in the first trial? Why wouldn't he just get retried again and go for another hung jury or go for an acquittal? Why would he take a plea deal which guaranteed him jail time, prison time, right? Well, there's a lot of reasons for doing that. First of all, the plea deal wasn't a bad plea deal. Now, I know a lot of people instinctively recoil at the idea of taking a plea deal, but folks, it all depends on the legal risks you're facing. And in this case, the legal risks were just short of capital punishment. The rest of his life in prison without possibility of early release. So what was he offered in turn? He was offered 6 years prison time. So he's 18. He might have been 20 by the time this happened, 21 by the time he took the plea. 21, he's looking at 6. If he does the whole 6, he's out when he's 27. From my perspective, still a young man. And he might well not do the 6. Might get released a little as a third of the time for good behavior. Could be out in 2. Could be out in 3 or 4. That sucks, and it's a felony conviction. I believe he took the plea on manslaughter. So still a serious felony conviction. He'll have that his whole life. Never get rid of that. Lose all the rights that come with being convicted of a felony. But he's not spending the rest of his life in prison. So when you're offered that kind of deal, it's hard not to take, especially when you consider the unbelievable costs involved in defending yourself in a murder trial. As I talked about at the very start of the show, these killing cases, murder, manslaughter cases, can easily hit a couple $100,000 before the trial, just pre-trial expense. So imagine you're going through that first trial. What percentage of your resources, and in this case, of course, probably his parents' resources, what percentage of your resources are you willing to spend to try to avoid spending the rest of your life in a cage? Probably a very high percentage, maybe more than 100%, right? Maybe you beg, borrow, and steal every penny you can get from family, friends, wherever. GoFundMe to raise as much money as you possibly can for that legal defense. And then you spend all that money and you get a hung jury. Folks, that's a win from my perspective. Not as good a win as an acquittal, but it's a win compared to a conviction. You're not going to prison for the rest of your life. Done deal. You're still in the fight. But the prosecutor says, well, we're going to try you again. Well, if you spent 150% of your resources on the first trial, what do you think you have left for the second trial? Probably not anything. And we don't like to think we live in a world where the amount of resources you can bring to a legal fight doesn't influence the justice you get or the legal outcome. But folks, it does. There's a huge difference between a $300,000 or $400,000 legal defense and a $30,000 or $40,000 legal defense. They're not the same things. So if you ended up with a hung jury after spending a couple $100,000 and now you have nothing left, you're going into the second trial with $20,000. You think the legal outcome is going to be better? Probably not. And then they offer you a 6-year plea. I tell you, that's hard to say no to. So I imagine I was not at all involved with the case. I was interviewed by the case for some news outlets, law and crime, cable TV news and such, but had no personal involvement with the case other than that. But I imagine that was what was going through Steve Jones's head when he got that plea offer. Let's see. A couple questions I'm just going to knock out real quick because I can't really answer them. So Johnny asks, I'm a platinum member. Could you give us advice on what to say or not to say if we ever have to call 911 after a self-defense event? Johnny, I can't really answer the question because in our full day law self-defense advanced course, we spend over an hour talking about nothing but interacting with the police in the aftermath of a use of force event. It's a very detailed, nuanced, complicated topic that I couldn't possibly answer in a Q&A format. So listen, if you're interested enough to be a platinum member, and I greatly appreciate the support, I would just urge you to make sure you take advantage of the opportunity to do that law self-defense advanced course. We have it on DVD. We have it streamed. That is the single best way to get that education. I just couldn't possibly do it in a Q&A format. JLM says, discuss whether excusable homicide is included within the doctrine of imperfect self-defense. So again, I'm just going to do this quickly. If you've been exposed to this before, it'll sound very familiar. If it's all new to you, it's probably not that helpful. If you're a law self-defense member, you've seen me write blog posts and do videos and podcasts on these topics a lot, so it ought to be familiar to you. But these phrases, excusable homicide, imperfect self-defense, justifiable homicide, these are all distinct legal concepts. So when something is justified, it's free of legal liability. So it does not carry legal liability. When something is legally excused, it does not carry legal liability. So either justified, whatever, justified homicide, or excused, whatever, excused homicide, they're both killings that are free of legal liability. But they do differ in an important way. A justified homicide, and we're talking in legal theory here, but a justified homicide, the concept behind that is a homicide in which the outcome was a social good. So a rape victim kills her rapist. A armed robbery victim kills the armed robber in lawful self-defense, justified self-defense. It's better for society that the innocent victim survived and the criminal aggressor died. If those were the only two outcomes, right? One of them had to live, one of them had to die. It's a social good that the innocent victim of the crime died. That's what makes it justified. Excusable homicide is different. It still carries no legal liability, but it's a killing that's relieved of legal liability under circumstances where the outcome was not a social good, but we are relieving liability anyway. And this might be an example. A good example is the insanity defense. So someone goes clinically insane. There's something wrong with their brain. They imagine that the person they're looking at is an alien from Mars who's going to destroy all life on Earth, and they shoot it. In their heads, they genuinely believe that's an alien creature that's going to end human life on Earth, and they shoot it. So from a mental state perspective, they're not killing a human at all. Right? That's what they believe. Of course, they're wrong. They're insane. They just killed a human. In fact, they just killed a pediatric oncologist. Is that a social good that an insane person killed someone who saves children from cancer? Of course not. That's a terrible loss to society. So it can't be justified. It's not a socially good outcome, but it might be excused because society might say, listen, it's terrible that happened, but we're not going to hold the killer responsible because they were genuinely insane at the time they committed that act. So that's an excusable homicide. It's not a good outcome, but it nevertheless will not carry criminal liability. Imperfect self-defense is completely different. Imperfect self-defense, as I said earlier, is where a person has a genuine good faith belief that the elements of self-defense have been met, justifies their use of force, but their belief is unreasonable, irrational. And because it's unreasonable, and the belief has to be reasonable to qualify for perfect self-defense, because their belief is genuine but unreasonable, it can't qualify for perfect self-defense, can't qualify to acquit their use of force, to relieve them entirely of legal liability, but it might mitigate their crime from being one of murder, life in prison without possibility of parole, to being one of manslaughter, 10 years, 20 years, possibility of early release after a third of that time, and so forth. Okay, I think I went through all the questions on our list. Let me take a look at the membership site. Someone mentions AP is reporting that Kyle Rittenhouse has been released on $2 million bail. Well, that would be good news for Kyle Rittenhouse. Certainly every day he was in prison, he was in danger of being murdered in prison. I hope he has a safe place to go to. Assuredly, as a condition of release, he will not be lawfully permitted to be in possession of weapons. So I hope he has people around him who are prepared to defend him. The lunatics are out there. Let's see. I think that's about it from the membership comments. Let me take a look at our Facebook page. Okay, roll up to the top. I'll take a sip. And while I'm doing that, folks, I'll remind all of you, if you like this kind of content, I would urge you to consider a trial law of self-defense membership. It's extremely inexpensive. 99 cents gives you access to all our membership content for 2 weeks. If you decide to cancel within that 2-week period, no questions asked, we'll give you not just your money back, but 200% of your money back. It's a negative risk proposition, folks. If you do decide to stay a member, it's only about 33 cents a day, less than $10 a month for hours and hours of this content every week, every month, every year. And our goal, of course, is to translate all this legalese into plain English so it's actionable for you, so you can be more decisive in defending yourself and your family in the physical fight because of your confidence that you're doing so well within the legal boundaries, and to make you hard to convict. I mentioned earlier that for a prosecutor to convict on a self-defense case, he is to disprove self-defense beyond a reasonable doubt. It's a very high threshold. Easy to do if the defendant hands the prosecutor what he needs to get that conviction, to disprove self-defense beyond a reasonable doubt. Hard to do if the defender's use of force was so well within the legal boundaries that it's very difficult to disprove beyond a reasonable doubt. You make yourself hard to convict. And if you're hard to convict, prosecutors do not like to take those cases to trial. They have so many cases that are easy wins on their desk. The hard cases get deprioritized as a general rule. That's what you want. You want to be the lowest priority on that prosecutor's desk. That's how you get charges dismissed. Worst case, that's how you get a favorable plea deal. So you can try out Law of Self-Defense membership again at lawofselfdefense.com/trial. Just 99 cents, 200% money back guarantee. All right, let's look at Facebook here. Hey, Will. Hey, Oscar from Texas. And Lorraine. I hope you got your questions answered, Lorraine. Let's see. Oh, thank you, James. James says, anyone participating here on Facebook needs to get a Law of Self-Defense membership. Always appreciated. Christmas is coming, folks. You could do it. You could do it for friends and family, too. Just think about it. We should set that up. We should set up some kind of gift cards. I'll have to talk to my staff about it. David asks, could Rittenhouse be pardoned by the president before the trial concludes? Well, he's not charged with any federal crimes. My understanding is the president can only pardon for federal crimes, not for state crimes. So Rittenhouse has been charged with state crimes. The governor of the state, I guess it would be Wisconsin, right? I presume that's a Democrat governor. What are the prospects the governor of a state's going to acquit someone who the media is characterizing as a murderer of protesters? So no, I don't believe we'll see any pardon from anybody for Kyle Rittenhouse. I hope he gets a good legal defense. I mean, I've spoken to his legal team very informally. I'm not part of the legal team by any means. Don't want to create that impression. We've discussed it, but nothing's come to any decision. The ball's in their court on that. But certainly he has a very prominent, very legally capable, very well-financed legal defense, which is, I mean, it's almost all you could hope for in this kind of situation. So, all right, well, those look like all the questions. We may wrap up just a couple minutes early today, which will make up for some of the last week's stuff. So, folks, if that is out of the way, I will just remind all of you before we go. First of all, we do the show every Thursday, 4 p.m. I know today's Friday. Normally Thursdays, 4 p.m. Eastern Time. Feel free to join us. It's the only content we do that's open access. You don't need to be a member of Law of Self-Defense, but it's the only content we do that's open access. If you like it, you have friends and family who would benefit from learning more about self-defense law, the way that we talk about it, please encourage them to take advantage of this free showing on Facebook, recordings on Facebook and on YouTube and on the Law of Self-Defense membership site. It stays free on all of those. Again, this is how we grow the Law of Self-Defense community. It's really the only way we do it is word of mouth. So if you like what we have to offer, please let others know, encourage them to expose themselves to it as well, and then they can make the decision of whether or not being a member is a good option for them. In the meantime, remember, as always, folks, if you carry a gun for personal protection, if you carry a gun so you're hard to kill, that's what we're really talking about, right? That's why I carry a gun. So I'm hard to kill, so my family is hard to kill. Well, then you also owe it to yourself to make sure that you know the law so that you're hard to convict. All right, folks, I'm Attorney Andrew Branca with Law of Self-Defense. Until next time, stay safe.